Good
Mr.
afternoon.
Schmidt. Good afternoon, Mr. Schmidt. Are you ready?
Yes, sir.
All right. Who do you have with you?
Keith Eddington.
This is cause number CR 22-132, State of Texas versus Keith Allen Eddington. Mr. Eddington, I see that the state has filed a motion to withdraw its motion to revoke and terminate. The court also finds that part of the agreement is upon them withdrawing it and continuing you on community supervision, you're being ordered to serve 30 days in the county jail as a condition of community supervision for your positive marijuana use. And also you're being amended for an additional cost of $500 associated for your attorney fees that have been paid by the county on your behalf. Do you understand that if the court withdraws the motion and amends your community supervision conditions, that those two things will be included, which means that the 30 days, should you receive a subsequent motion or revoke, and if you're revoked on that and sentenced to any kind of jail time or prison time, you would not be entitled to that 30 days credit. Do you understand that?
Yeah.
All right. All right. Then the court hereby grants the state's motion to withdraw and terminate. The court will amend the conditions of community supervision to include 30 days in jail as condition of community supervision. I'm assuming that 30 days is already time served.
Yes, Your Honor.
Yes, sir.
We need to get that. It's not located in the order. The dates are not located. So I think we should probably get something on the record filed later at some point.
Yes, sir.
To show what those dates are. So if we're ever calculating credit time in the future, it'll be clear on the record.
And Your Honor, if the court would like to amend, I would recommend today 10/30, but going back to 10/1 would give us a clear 30 days.
All right, so 10/1/2025 through today.
Yes, sir.
Any objections, Mr. Schmidt?
Well, I on the 30th day, I'm not sure as far as calculations are concerned, whether they consider him being here today as a day served and whether he will be released today or tomorrow. I'm not sure how the jail would calculate that. It could go either way. It has gone either way in my estimation. You understand what I'm saying, Judge?
How many days are there between, are we counting 10/1 as the first day served?
Should be, yes.
Yeah, today being the 30th day. Yeah, he could be released tomorrow.
Yes,
Is that
sir.
what y'all want to do?
That's not what I want to do. He's got sufficient credit to cover. If we could just back that up one day, the 10/29, 30 days back, that way, get out today for sure.
Mr. Hartwell?
No objection to doing that, Your Honor. So I guess it'd be 9/30 to 10/29.
Yes, sir. That's good.
All right, the court has written in jail time, a conditional probation, September 30th, 2025 through October 29th, 2000. October 29th, 2025 on the bottom of the order granting this motion to withdraw.
Thank you, sir.
All right, Mr. Eddington, do me a favor. Stay out of my jail, please.
Yes, sir. All right. Okay. You can go sit back open. Okay. Isaiah, come on down. You don't need that. This is Isaiah Valencia Fulton.
All right, this is cause number CR 23-20, State versus Isaiah Ernesto Valencia Fulton. State's motion to revoke. Go ahead, Mr. Schmidt.
That's correct, Judge. Mr. Valencia Fulton was recently bench warranted to our facility, I think, a day or two ago, yesterday. I haven't had an opportunity to meet with him, and I suspect we'll be able to resolve him pretty quick, so we'd ask for another reset on him.
Any objections from state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Valencia Fulton for Tuesday, December 2nd. At 9 a.m. or at 1:30.
Isaac Jenkins.
No. She's.
All right, this is cause number CR 24-183, CR 25-126. State of Texas versus Isaac Anthony Jenkins. We're set for motion to revoke and docket call.
That's correct, Judge. On the CR 25-126, we're going to ask for an additional docket call. Keep working on that case and ask that the CR 24-183 be carried with it.
Any objections from the state?
No objection, Your Honor.
All right, court will set Mr. Jenkins for a final docket call December 16th, and we'll set the motion on the same date.
So,
Who's next?
this is Seth Atkins.
This is cause number CR 22-368, State of Texas versus Seth Edward Atkins. Motion revoke. Go ahead, Mr. Schmidt.
That's correct, Judge. It's my understanding that Mr. Atkins has received 3 additional felony charges. I believe the state intends to amend their motion. In addition to that, I need to meet with Mr. Hartwell about the new allegations. So we'd ask for his case to be reset.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court sets Mr. Atkins in for December 16th at 1:30.
Yeah. And Judge, also, I'm not sure if Mr. Atkins is being held on the CR 22-368. He was on bond prior to being arrested on these new charges. In the event that his bond is still active, I'm not certain. We'd ask that the court find it insufficient. And attach that to him while he's in custody.
All right, court will investigate whether or not the bond is active. If not, then if it is, then the court will find this bond to be insufficient.
Yes, sir. Thank you. Thank you, Your Honor.
You're welcome.
And that's all I have for right now. I've got one more waiting on paperwork, and then I'm not sure if Mr. Manning's ready or not.
Ms. Abraham, I'm going to go ahead and take up Mr. Sanders here on his writ.
Okay,
So I'm just going to mute you. I'm going to mute your device.
okay, thank you, sir.
All right, court calls writ number WR 25-00043, Ryan North versus the state of Texas. Mr. Sanders, you filed a writ seeking bail reduction. Is that correct?
Yes, sir.
All right. Are you ready, Mr. Sanders?
Yes, and Judge, there should be 4 total bases. There's
Yes, they are. I see here. They're just separated. Let's see, I've got WR 25-41. WR 25-42. WR 25-43 and WR 25-44. Yes, thank you. I appreciate you bringing that to my attention.
And yes, we're ready.
All right, state ready?
State's ready, Your Honor.
All right, go ahead, Mr. Sanders.
All right, thank you, Judge. Your Honor, if we would call Tika Alexander to
All right.
testify.
All right, Ms. Alexander. We're gonna come up here to the witness stand. All the way around this way. Before you enter, I'm gonna have you raise your right hand so I can place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Watch your step. That chair moves around, you can pull it back, have a seat. And ask that you just kind of move as close as you can to the microphone comfortably. And during your testimony, you just speak up loudly and clearly so I can hear you. My court reporter over here is taking down everything we say. So it's important that we talk one at a time. Allow the attorneys to fully finish their question before you give an answer so that we're not talking at the same time, okay?
Okay.
Mr. Sanders, you may proceed.
Thank you, Judge. Ms. Alexander, first of all, state your name, probably spell your first name also.
Otika, Oteika.
And last name.
Alexander.
And you, you're a family friend with, Mr. Ryan Chris.
Correct. Yes, sir.
And do you understand that the purpose of today's hearing, it doesn't really have anything to do with the issues, the facts of the case or the guilt, innocence or anything like that, correct?
Yes.
So we're here just dealing with issues regarding his bond, 4 cases, correct?
Correct.
Now, and I know that you don't know all the details of the case. Turn that on.
It's the bottom button. The bottom one.
Oh, okay.
No, turn it over. Down there, yes.
Your left
Where your
thumb.
thumb is, where your other thumb is.
Left.
Left thumb, right there.
Hold it down.
There you go.
All
Perfect.
right.
Thank you.
Perfect.
That'll help.
All right.
Sorry, Mr.
All right,
Sanders.
thanks.
Sorry, Mr. Sanders. Go ahead.
No problem. Thanks. Ms. Alexander, is your understanding that, that this case initially was indicted in Smith County, correct?
Yes.
And I believe that Ryan was arrested there March 30th of 2025. Is that your understanding?
That's correct.
Okay. And then ultimately, and I know you may not know all the details that led to it, but ultimately that case was indicted June 26th and then dismissed on September 8th. Is that your understanding?
That's correct.
Okay. And then I believe a few days later, then he was brought to Van Zandt County. Is
Yes.
that your understanding?
Yes.
Okay. Now, as far as the bond goes right now, we've talked about it. We've talked about it with different family members. And so we're asking the court to grant a personal recognizance bond, a PR bond on each of the cases because of the time that he's been incarcerated without an indictment being on file. But alternatively, if the court does not grant a PR bond, we are asking for a reduction in the amounts. That's what you're understanding?
That's correct.
Okay. Now, right now, the total bond amounts, I believe would be 160,000, 100,000 for the aggravated assault charge, and then 20,000 for each endangering a child charge. Is that your understanding?
Yes, sir.
Okay. And I believe, have you or other family members contacted a bondsman or bondsman in the Van Zandt County area who would be willing to bond Ryan out?
Yes.
Okay. And approximately what percentage rate are they requiring you to pay down?
5%.
Okay. And so as it stands right now, if the bond is not reduced, you'd have to pay about 8,000. Is that correct?
Yes, I was quoted 8,000 to 10,000.
Okay. And as far as what the family can afford to pay, right now, y'all can pay about 5,000. Is that
That is correct.
Okay.
Yes.
And so what you're asking the court to do, and Ryan would be asking the court to do, is to, if a PR bond is not granted with each case, is to lower each amount to where the total is between 80 and 100,000.
Correct. Yes.
Okay. And I believe it's not just you, but it's his mom and maybe some other family members too who would be paying.
Mom and grandmother.
Okay. Okay, all right. And that's something that, that as of right now, the family of the group will be able to put forth about $5,000 to bond him out. Is that right?
Correct.
Okay, all right. We've passed the witness, Your Honor.
Mr. Hartwell?
Yeah, thank you, Your Honor. Ms. Alexander, are you familiar with Mr. Norse's affiliation with the Northside Coons?
I am not, no, sir.
Are you familiar with what that organization is?
No,
No. So would it surprise you to learn that he is affiliated with a criminal street gang?
never knew it.
Uh, and I understand that family's willing to help. Do you know of any property or assets that Mr. Norse might have?
No, sir.
So you don't know if he has the ability to come up, if he were to sell assets or leverage any of those assets, if he could come up with the 5%?
That I do not know. We just will have cash.
No further questions, Your Honor. Thank you.
Mr. Sanders, anything further, Ms. Alexander?
Just briefly, Judge. Ms. Alexander, Mr. Norris has been incarcerated since March 30th, 2025, correct?
Correct.
Okay, so he hasn't been in a position where he can work to earn money or even acquire any assets or sell anything since he's been locked up for this period of time. Is that right?
That is correct.
We pass it, Your Honor.
Mr. Hartwell?
Nothing further, Your Honor. Thank you.
Thank you, Ms. Alexander. You can step down.
Okay,
What's your
thank you.
statements? Mr. Sanders, any additional witnesses or evidence?
No other witnesses, no other evidence, Your Honor. We'd rest and argue.
Right. State any evidence?
Your Honor, state would call Aaron McLeish.
Let's get a release. You'll raise your right hand. I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court states the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Watch your step. Have a seat. I'm going to spare you the rules. I think you understand the rules better than most. So, Mr. Hartwell.
Thank you, Your Honor. Good afternoon, Deputy or Investigator McLeish. I'm sorry. Can you please state your name for the record and spell your last name for the court reporter?
Yes, sir. It's Aaron McLeish, McLeish.
How are you presently employed?
As an investigator with the District Attorney's Office.
As an investigator, are you a licensed certified peace officer?
Yes, sir, I am.
Can you tell me some of your duties as an investigator?
Uh, Intake cases, review them, prepare them for trial and hearings such as this.
And as part of your duties, do you conduct any, or do you assist with investigations, prepare search warrants, arrest warrants, things like that?
From time to time, yes, sir.
Do you recall preparing an arrest warrant or being involved in an arrest warrant in this case?
Yes, sir.
Your Honor, may I approach the witness?
You may.
And Investigator McLeish, handing you what's been marked as State's Exhibit Writ 1. And I'm sorry, Mr. Sanders, but
I've been provided with copies of this. I don't have any objection on it.
does that document, or how many documents are there in State's Writ 1?
4.
Do you recognize those 4 documents?
I do, yes, sir.
Are they true and accurate copies of documents that you have been involved with?
Yes, sir.
Your Honor, State would offer State's Writ 1.
No objection.
State's writ 1 is admitted.
Investigator McLeish, can you tell me what are State's Writ 1?
These are arrest warrants for the charges for Mr. Ryan Norris, the charges that originated in Smith County for prosecution, but were then transferred to Van Zandt County, if you will.
And are you able to tell from those documents when the arrest warrant for Van Zandt County were served on Mr. Norris?
Yes, sir. They were served on September 9th, 2025. Can you tell who served those warrants? I did.
And can you tell the court where you served those warrants?
At the Smith County Jail.
And can you tell me about that service of process? Just kind of give a description of how you served it.
We were aware that he was in custody in Smith County. We were also aware that there were plans to dismiss those charges in Smith County pending the charges here in Van Zandt County. And so I was trying to make that process as fluid as possible, as continuous as possible, if you will. So I learned that Mr. Norris was on the docket on September 8th, 2025, with plans that they were going to present motions to dismiss to that court. I was there in court that day. I heard the presentation of that motion. I heard the judge presiding over that court acknowledge the motion. However, he declined at that moment to sign the order, and he reset the case for the following day. I had to come back to work here in Van Zandt County, so I returned with plans to return the next day on September 9th, which I did. However, by the time I returned on September 9th, I learned that the judge had in fact signed those motions for dismissal the prior day. So Mr. Norris was not in court where I was on September 9th. He was in fact in the Smith County Jail. So I went to that location and served these warrants there.
And did you serve Mr. Norris personally?
I did not, no, sir.
Who did you serve on his behalf?
I gave these documents to the jail staff. They were in the booking area. When I told them who I was and what I was there for, they nodded in acknowledgement. They were expecting me already. They accepted the documents. I asked them if I needed to go back and serve him in person, and they said no, they had a process for it. They accepted the documents on my behalf.
No further questions, Your Honor.
Mr. Sanders, your witness.
Judge, I don't have any questions.
Thank you, investigator.
Thank you, Your Honor.
Mr. Hartwell, any additional witnesses or evidence?
Your Honor, I would proffer a criminal history. I don't have access to one right now, so I can't give that to the court. And I know we're supposed to at some point get access to that TSR system. I don't have access yet, so I cannot provide that to the court at this time.
Anything further?
Nothing further, Your Honor.
Mr. Sanders, anything further?
No, Your Honor.
All right, argument, Mr. Sanders.
Yes, Judge. As our writs indicated, we're asking for PR bond with each case. The ag assault set at 100,000, and each endangering case is set at 20,000. And just the reason I was asking for a PR bond, I know he hasn't been in Van Zandt County Jail for 90 days, but as far as I understand, the case still hasn't been indicted. He was in the Smith County Jail starting March 30th. And wasn't indicted until June, I believe June 26th. So there was about 88 days that he was confined without being under indictment in Smith County. And then, and I know that this doesn't, impose any kind of requirement to act as far as on a PR bond with the whole 90-day rule. But when you look at it that way, over 80 days in Smith County and then over 50 days in Van Zandt County, he's been incarcerated since March 30th, and there's over 100, probably around 140 days total. He's been incarcerated and not under indictment. And then, and I know I put some detail in in each writ application as far as what happened. Basically, the state didn't have all the evidence in Smith County. The prosecutors didn't have all that together. And once all that was put together between law enforcement and the DA's office, I think we finally convinced them that what they were charging Mr. Norris with in Smith County did not happen in Smith County. So all the allegations would have taken place in Van Zandt County along I-20 based on 911 calls, putting all that information together. And so that's why I believe they contacted Van Zandt County, ultimately dismissed the Smith County cases. And I think as Investigator Leach was talking about that Monday morning when the state announced they'd be dismissing it, they didn't have the dismissal motion and order prepared yet. And then I think later the day they got that to the court, and then Judge Russell signed the dismissals. But based on that scenario, that's why we're asking for a PR bond. As I said with Ms. Alexander, alternatively, if the court doesn't choose to grant a PR bond, we would ask for a bond reduction. We would ask that the aggravated assault be reduced to 60,000, and then each of the endangering charges be reduced to 10,000 each. I believe that based on what Ms. Alexander testified to, that would be a reasonable amount that the family could afford to bond him out at. Additionally, Judge, I put in the motion, I think I also attached a copy of the affidavit on prosecution where the the mother of his kids indicated that she did not want to press charges on these cases. And so based on all that, we're asking for the PR bond on each case, and if not, then a bond reduction with each case.
Thank you, Mr. Sanders. Mr. Hartwell.
Thank you, Your Honor. Your Honor, state would be opposed to personal bonds or a reduction in this case due to the seriousness of the allegations here. Aggravated assault plus child endangerment would at least indicate that the two are connected. Further, Your Honor, as far as the time goes, what happened in Smith County, it doesn't bear on when Van Zandt County's warrants attached. Van Zandt County warrants attached on September 9th, so the state's position is that that's when the 90 days would start to run from September 9th, not from the original arrest date in March, based off of Smith County arrest warrants. So Your Honor, state would be opposed to either personal or reduction. Further, Your Honor, even if this complaining witness doesn't want to seek prosecution, here we've got endangering children. So state would be concerned for their welfare as well in this case.
All right, thank you, Mr. Hartwell. Any final word, Mr. Sanders?
No, Your Honor.
Okay. All right, then what I'm going to do is I'm going to take it under advisement. I'm going to review the evidence admitted by the state. I will take the testimony and arguments under advisement, and I will also review the defendant's criminal history through the PSRS system as I'm required to by statute. Once I make that review, then I will issue a written order, and I'll provide it to both the council via email. And I'll plan to make that, if not by this afternoon, then by in the morning. Okay.
Thank you.
Thank you.
All right, there's nothing further in this case, and we're adjourned.
Your Honor,
Yes, ma'am.
Mr. Manning is just about through with all of his. We're still waiting on Mr. Schmidt's, paperwork. He has one plea, but we haven't received those, so we should be
Okay.
ready in about 5 minutes.
Okay, I'll be on standby.
And we have Mr. Halbert here from this morning.
Oh, excellent. Okay, so,
So when Mr. Manning gets up, we'll
Okay.
do that one.
all right, I'll be on standby.
Your Honor, we're ready when you are.
Okay, I'm ready when you are.
I need you to, our video's disabled. Thank you, sir.
All right, Mr. Manning, who are you ready on?
This is Mr. Halbert from this morning. Hey, Judge, if I may, I was able to get a hold of Mr. Halbert almost immediately once I left the court this morning. I had some good contact information for a family member who put me in contact with him. He was able to come down from his job up in Wills Point and get down here within 30 minutes of when I requested. And we were able to confirm the address that he lives at and that he had given originally was not the address that was on the notice that was sent out.
You're saying the address that he gave on his PR bond is not the address we sent notice to?
The address that he gave me that where he's residing currently was not the same address as the one on the PR bond. I don't have the information for the PR bond, what address was put on there. But I do know that the two addresses that he have did not match up.
What it sounds like to me is Mr. Halbert didn't update his address with the court and we sent it to the address he told us to send it to. And here he is. So this is cause number CR 25-203, State versus Randall James Halbert, set for arraignment. Go ahead, Mr. Manning.
Judge, his name is spelled correctly. He understands the charge against him as well as the range of punishment. Pleads not guilty and requests to be set on pretrial for discovery.
All right, the court will find that Mr. Halbert has waived the formal requirements of arraignment, enters his plea of not guilty into the record, and the court sets this matter for pretrial on Thursday, December 4th at 9 a.m.
Thank you, Judge.
And Mr. Halbert, if you change your address, you have to update that with the court. Otherwise, the court doesn't know how to contact you. And so
Yes,
you're fortunate, and you ought to be thankful to Mr. Manning for going the extra mile for you and reaching out to family members and contacting you and getting you down here. Otherwise, I would have found your personal bond to be insufficient, issued a warrant for your arrest, and you would be wearing orange, but it would be my orange, not your orange.
Yes, sir.
All right, for the record, the court, having taken the judgment not sought under advisement, the court hereby revokes its oral pronouncement of a judgment not sought in the escape case. Thank you, Mr. Halbert. You're free to go.
All right, thanks, sir.
You're welcome. Who's next, Mr. Manning?
Judge, ready, Mr. Clardy.
Files number CR 25-181, CR 25-189, State versus Billy Eugene Clardy. Is this a play today, Mr. Manning?
Yes, Judge.
We just. Let me see if I can find it. All right, Mr. Clardy, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. All right, your name is Billy Eugene Clardy, is that correct?
Yes, Your Honor.
And Mr. Clardy, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
Yes, Your Honor.
What have you been diagnosed with?
Schizophrenic depression and anxiety, Your Honor.
Are you currently on medication or undergoing treatment for that?
No, Your Honor.
Do you feel like in any way today that mental health condition is affecting your ability to understand what's going on in this hearing today?
No, Your Honor.
Okay. In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, Your Honor.
Do you have any questions about any of the paperwork that you've read and signed today?
No, Your Honor.
Mr. Manning, do you believe Mr. Clardy to be competent, especially in light of his testimony regarding his mental health diagnosis? And if you do believe that he is competent, do you believe that he's entering into this plea agreement intentionally, knowingly, and voluntarily after having been informed of his legal rights?
Judge, I believe he is competent. I believe he is entering into this plea intentionally, knowingly, voluntarily. Judge, when I first met with Mr. Clardy, we discussed his mental health history. But I asked him at that time if that was going to affect his ability to participate, and he let me know that that time he was understanding what was going on. He understood the process as well as the roles of everyone involved, and he understood the allegations against him, was able to interact in those each step of the way.
Very well. Thank you, Mr. Manning. All right, Mr. Clardy, you have two cases today. One of them is a possession of a controlled substance. One of them, the other one is a fraudulent use or possession of identifying information. I see that the plea agreement today is that you would be pleading guilty to the fraudulent use or possession of identifying information. And in exchange for your plea of guilty, the state's recommending to the court that they would abandon their enhancement paragraph, which is in the indictment, and they would recommend that the court convict you of this third-degree felony offense, which has a punishment range of no less than 2 years in prison and no more than 10 years in prison. They're recommending that the court assess your sentence today at 5 years confinement in prison. They're also recommending a $1,000 fine, restitution of $180, and court costs of $290. And they are agreeing for the court to dismiss your other case, which is that possession of controlled substance. Mr. Clardy, is that your understanding of the plea agreement?
Yes, Your Honor.
And you're wanting the court to approve that?
Yes, Your Honor.
Mr. Clardy, at this time, I'd ask you, how do you plead to fraudulent use or possession of identifying information with a number of items being between 5 and 10?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
Mr. Clardy, has anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the admission of the stipulation of evidence?
No objection as offered, Judge.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Judge, I just note for the record that we have Mr. Clardy's credit time is agreed as 162 days.
Thank you, Mr. Manning. I was about to ask you that. 162. Okay. All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. In recommendation today, the court hereby convicts Billy Eugene Clardy of the third-degree felony offense of fraudulent use or possession of identifying information. The court assesses punishment at 5 years confinement in the Texas Department of Criminal Justice. The court orders the defendant to pay a $1,000 fine, $180 in restitution, $290 in court cost, and $20 in reimbursement fees. And the court dismisses under section 1245 indicted cause number CR 25-181. The court awards Mr. Clardy 162 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Clardy, when you are released from prison, if you've not paid off your fines and fees, then you're ordered to report to the Van Zandt County Courthouse and talk to the district clerk about setting up a payment plan to pay those things off. Failure to do so could result in another warrant being issued for your arrest. Do you understand?
Yes, Your Honor.
All right. Thank you, Mr. Clardy. I'm gonna have you step over to be fingerprinted.
All right, thank you.
You're welcome. Mr. Manning, you can go and get your next client. I'm gonna take just a moment to sign these.
Mr. Harrison. Saying that. The motion to revoke my case, they're gonna make the conditions of probation to include it's updated their year. They're gonna withdraw the motion to revoke and put you back on probation. Yeah. They're going to amend your conditions to include the updated cost. Start when you get out. So, the cost you paid down to $34. You still had $1,000 worth of fines. You had court party attorney's fees. You paid some of that, but not all of it. I don't have that. I don't have it breakdown of when you're ready. You're gonna complete the supervised program through the Van Zandt County Supervision Corrections Department, and you report weekly. You're in the first phase, and then upon the completion of the first phase, at this point, bi-weekly, and then after that, you'll return to the regular caseload. You understand that? I know the regular caseload. Okay. Put in weekly group counseling sessions, and you'll submit to a polygraph test showing that you have completed the intensive supervised probation. And you haven't had any relapses. You're showing them a polygraph. Yes. What's that for? To know that you haven't had any relapses while you're on the supervised. And you that what they do for race for? Yes, but they're also could you do polygraph tests because of way to meet you. Also, you need after 163 days credit. If you have any future issues and it sends you to prison, you will not have those 163 days that you spent in jail as credit for your probation. Or for your sentence. Okay, that would almost my part. They'll give me credit for them. No, they're taking that.
Yes.
That's 663 days you spent. If you get sentenced to prison, you won't get that out. So, but I'm getting probation. You're getting back on probation today.
It's put on,
So, there's the credit happening. 61 days originally, and then 102 days since you go. So, wonderful. Today,
Where's he live, John?
you live.
Wait a minute, same place, 201 VZC, 201 Van Zandt County Road 4124.
What city is that in, or what area? What city location is that in?
That can,
Canton.
What county road again?
Van Zandt County Road 4124.
4124?
Mr. Manning, can we call somebody else
Yeah.
when Mr. Harrison goes over his stuff with someone else, just so we? Thank
Oh,
you. sir.
sorry, Judge, we're ready.
Okay, sorry. I thought y'all were just going through the paperwork together. Does he have any questions about it? It sounds like he's confused on some things.
No, I'm good, thank you.
You're good? Okay. All right, court calls cause number CR 24-137, State of Texas versus J. Randall Harrison. Mr. Harrison, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
Thank you, Calorian. All right, Mr. Harrison, the state has filed a motion to withdraw its motion to revoke that was previously filed. And it appears to be based on an agreement between you and the state wherein you would serve 163 days in the county jail. You would receive credit for that time already served as outlined in the state's motion. And you would also have your conditions amended to include an additional $500 that is as a result of the motion being filed and you receiving a court-appointed attorney. Is that your agreement that you're making with the state?
Yes, Your Honor.
And you understand, Mr. Harrison, that should you receive a future motion to revoke, if you ended up being sentenced on this charge, you would not get any type of credit towards that 163 days. You understand that?
Correct. Correct,
Okay.
yes.
And Mr. Harrison, has anyone threatened you, forced you, or pressured you to make this agreement today?
No, sir. No.
Are you pleased with Mr. Manning as your attorney and the work he's done?
Yes.
Okay. And do you have any questions about anything else?
No, I'm good.
Okay. All right. Then the court will grant the state's motion to withdraw the motion to revoke. The court amends the community supervision conditions of Mr. Harrison to include 163 days confinement in the county jail. The court issues him credit for 163 days of time served for the dates outlined in the state's motion and court's order. And the court also orders Mr. Harrison to pay an additional $500 for attorney fees related to the filing of the state's motion. All right, Mr. Harrison, I need you to stay out of my jail. If you want to be on probation, you need to be on probation. You don't need to be on probation and in my jail, and on probation and in my jail. So you end up back in my jail, there's not going to be another probation. You understand?
Right.
All right. Just so we're clear.
Meet with this. Yeah. He just put back up the phone.
Mr. Manning, who do you want next?
Judge, oh, yes, they just brought in Mr. Mitchell, if we can do Mr. Roy Mitchell.
Mr. Mitchell, come on up. This is cause number CR 25-183, State versus Roy Mitchell III. And Mr. Mitchell is set for pretrial today. Go ahead, Mr. Manning.
Judge, at this time, we have no contested pretrial issues. Request to be set on docket call.
All right. Court finding no contested pretrial motions. The court sets Mr. Mitchell for docket call. You want that December 4th date, Mr. Manning?
Judge, that'd be good. Thank you.
All right. Court sets Mr. Mitchell for docket call December 4th at 1:30. Who's next, Mr. Manning?
Who's next ready on Miss Stevens, Alexis Stevens?
Ms. Stevens, come on down.
Yeah.
This is cause number CR 23-102, State versus Alexis Shea Stevens. Ms. Stevens, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. Give me just one moment. Let me pull up your paperwork.
Yes, sir.
All right, Ms. Stevens, you appeared before the court in October of 2023, I believe on the 26th. You pled guilty to the state jail felony offense of theft of property between $2,500 and $30,000. The court heard the evidence that day about your case and found that you were entering into a plea agreement. The court approved your plea agreement and placed you on deferred community supervision for a period of 4 years. And the court did not assess a fine that day. During that period of community supervision, The state of Texas filed a motion to adjudicate your guilt and to revoke your community supervision, and they've alleged 9 separate allegations of violations. Have you had enough time to review those allegations with your attorney, Mr. Manning?
Yes, sir, I have.
Are you pleased with Mr. Manning as your attorney and the work that he's done?
Yes, sir.
Do you have any questions about any of the paperwork that you've read and signed today?
No, sir.
I see that you do have a plea agreement in this case. It appears that upon you pleading true to one or all of the state's allegations, the state's recommending that the court adjudicate your guilt, which means convict you of that offense, that your community supervision be revoked, and that you be sentenced to 8 months confinement in the Texas Department of Criminal Justice in the State Jail Division, and that you be ordered to pay the balance of your fines and fees, which are restitution of $8,455, reimbursement fees of $120, and court costs of $240. And then you're going to receive any credit time that you're entitled to. Mr. Manning, how much credit time did you and the state calculate?
I believe we calculated 122 days. Give me just 1 second. That's correct, Judge. We agreed that there was 122 days credit.
All right. So Ms. Stevens, you would receive that credit towards that sentence. Did you have something else, Mr. Manning?
Yes, I apologize, Judge. I'd also note for the court, when we were reviewing the motion to revoke paperwork, I noted that counts 4 and 5 on the motion revoke seem to be repetitious. I just point that out that while she is pleading true to all counts, it looks like counts 4 and 5, or paragraphs 4 and 5 are the same allegation.
Yeah, I'm reviewing that now, and it appears that you are correct. I think the only difference is count 4 says condition M2 and count 5 says condition M3, but they appear to be both for supervision fees for the exact same months and year. So I'm not sure which one that's. Ms. Burns, is condition M2 or M3 supervision fees?
M2 is supervision, M3 is restitution.
Okay, so there's no, I see that there's going to be restitution ordered in the judgment, but it's not included in the motion. Any objections to that, Mr. Manning?
No objections, Judge.
Okay. All right. Mr. Manning, do you believe Ms. Stevens to be competent? And if so, is she entering into this intentionally, knowingly, and voluntarily, in your opinion?
Judge, she is competent. I believe she's entering into this plea intentionally, knowingly, and voluntarily.
All right. At this time, Ms. Stevens, how do you plead to the counts alleged in the state's motion to adjudicate? Are those counts true or not true?
They're true, Your Honor.
And Ms. Stevens, you heard Mr. Manning bring up an issue that was involved in your paperwork. One of the conditions says it's duplicated and says that you didn't pay supervision fees, but are you indicating to the court that you also did not pay your restitution in this matter?
Yes, sir.
Okay. All right. And Ms. Stevens, are you pleading true to these counts because the allegations are in fact true?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead true to any count?
No, Your Honor.
All right. Then the court will accept the defendant's plea of true to each and every count as alleged. The court will also admit into evidence the defendant's waiver of rights and plea of true to the state's motion to adjudicate. Takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, then based on the evidence before the court finds that the defendant, Alexis Shea Stevens, has violated the terms and conditions of her community supervision. Court will follow the plea agreement today. Court hereby adjudicates her guilt, convicts her of the offense of theft of property between greater than or equal to $2,500, less than $30,000, a state jail felony. Court finds all counts alleged to be true. Court assesses sentence, revokes community supervision, assesses sentence today at 8 months confinement in the Texas Department of Criminal Justice State Jail Division. Court orders her to pay the balance of her financial obligations. The court confirms arrearages in restitution in the amount of $8,455, reimbursement fees of $120, and court costs of $240. And the court awards Ms. Stevens 122 days credit towards her sentence for the time that she's already spent in jail on this cause. Ms. Stevens, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from custody, if you've not paid off your financial obligations, then I need you to report to the, Ms. Abraham, can you tell whoever's talking in there? I can't hear a word.
Okay, we can't hear. Michelle. Judge can't hear.
I'm sorry, microphone's really sensitive. I can't hear myself talk when I'm hearing you. So Ms. Stevens, once you are released from custody, if you've not paid off your fines and fees, then you're to report to the courthouse, make a payment arrangement, and try to get those things discharged to avoid having a warrant issued for your arrest, okay?
Yes, sir.
All right, Ms. Stevens, I'm gonna have you step over to be fingerprinted. All right, Mr. Manning, who's next?
Judge, ready on Mr. McMillan?
All right, go ahead and bring him down. I'm gonna go ahead and sign Ms. Stevens' paperwork while he's on his way down.
Yes, Judge.
Court cause number CR 25-240, State of Texas versus Michael Joseph McMillan. And we're set for arraignment. Are we doing a plea today, Mr. Manning?
Yes, Judge, we've actually waived our right to an indictment, and we're proceeding on information.
Give me just a moment. Let me find the paperwork. All right, Mr. McMillan, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Your name is Michael Joseph McMillan, is that correct?
Yes, Your Honor.
And Mr. McMillan, you're before the court today because you've been indicted with a third-degree felony offense of possession of a controlled substance in penalty group 1 between 1 grams and 4 grams. In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done for you?
Yes, sir.
Are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
No. No, sir.
Mr. Manning, do you believe Mr. McMillan to be competent, and if so, that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
Judge, I do believe he's competent, and I believe he's entering into plea intentionally, knowingly, and voluntarily. Additionally, Judge, just a slight clarification. As I mentioned before, this is a plea proceeded on an information, not an indictment.
Yes, sir. I appreciate that. Yeah, I was about to go over that with Mr. McMillan. Mr. McMillan, as part of your plea agreement today, you have signed a waiver of indictment. And that document means that you understand that you have the right to have your case presented to a grand jury, and for a grand jury to review the evidence and determine if there's enough evidence to hold you over for trial to prosecute you, and that no one in the state of Texas can be prosecuted for a felony offense without first receiving an indictment from a grand jury. Are you waiving the presentment of your case to the grand jury and allowing the state to prosecute you without taking the case to the grand jury? Is that what you want to do today?
Yes, Your Honor.
And you understand that once you waive your right to an indictment, that right will not be restored to you later, meaning that if the court goes along with your plea agreement today and puts you on probation and you violate and you end up back in court, you can't later say, Judge, I wasn't indicted and I want to go to the grand jury. You understand that today would be that day. If you want a grand jury indictment, you have to assert that right today. Once you waive it, it's not going to be given back to you. You fully understand that?
Yes, sir.
All right. And Mr. McMillan, you understand that by waiving your right, you're also waiving your right to, well, let me put it this way. Once you waive your right to a grand jury indictment and you allow the state to prosecute you on an information, then that has the same legal effect as your case going to the grand jury. You understand that?
Yes, sir.
And Mr. McMillan, has anyone threatened you, forced you, or pressured you to plead guilty today or to waive your indictment today?
No, sir.
All right. All right, Mr. McMillan, you are charged by information and you've waived the indictment on the felony offense of possession of a controlled substance in penalty group 1 or 1B greater than 1 grams, less than 4 grams, a third-degree felony that does carry a range of punishment of not less than 2 years and not more than 10 years in prison should you be convicted and sentenced. Further, you could also be fined up to $10,000. I see that there is a plea agreement in your case. Upon you pleading guilty to this offense, the state's recommending to the court that the court consider the evidence but not convict you, but rather to place you on 3 years of community supervision, assessing a $1,000 fine, plus ordering you to pay court costs of $290, reimbursement fees of $515. And as part of the plea agreement, the state is also agreeing to reject a possession of marijuana less than 2-ounce case. They would not prosecute you on that. And you would also, as part of the agreement, you would have to undergo a substance abuse evaluation and follow all the recommendations of that. Is that your agreement, and that's what you're asking the court to approve?
Yes, sir.
All right, Mr. McMillan, understanding all of those things, I would ask you, how do you plead to possession of a controlled substance in penalty group 1 greater than 1 gram, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And you told me previously no one's forced you to do that and no one's threatened you to do that, correct?
Correct.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the evidence?
No objection as offered, Judge.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court is going to consider the evidence at this time. All right, so Mr. McMillan, I do want to discuss one issue with you here. I see here on the stipulation of evidence, it says that the suspected controlled substance that was seized from you that day by Officer Moore of the Van Police Department has not been chemically tested at the laboratory. And so the state of Texas does not have any type of report that confirms the actual chemical makeup of the substance to tell the court whether or not this is in fact a controlled substance. But you're saying today that you know it to be methamphetamine and you're admitting that it's methamphetamine. Is that correct?
Yes, sir.
Okay. And you're waiving the you're waiving the laboratory testing of that substance at this time.
Yes, sir.
Okay. All right. Then based on the evidence presented to the court finds that there's enough evidence to convict the defendant. Court follows the plea agreement, places the defendant on deferred community supervision for 3 years on the offense of possession of a controlled substance, third-degree felony. The court assesses a fine of $1,000, court costs of $290, reimbursement fees of $515. And further, the court finds that the state is rejecting for prosecution and the court is considering it under section 1245, DA 2025-944. Further, the court orders the defendant to complete a substance abuse evaluation and follow all recommendations of that as a condition of community supervision. Mr. McMillan, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Mr. McMillan, if you have a drug problem, and it looks like you do, now is the time to get help with that while you're on community supervision. If you cannot address it and becomes a problem, or at least to any other problems, then you're going to be revoked and sent to prison. You understand that?
Yes, sir.
All right, so you get to decide now. You're given the opportunity to be on probation. We're going to see what you make of it, right? I'm going to have you step
Yes,
over
sir.
to be fingerprinted.
Thank you.
You're welcome. Mr. Manny, I'm going to sign, but if you want to go ahead and bring your next client.
Yes, Judge.
Sure, yes.
Mr. Manning, who's next?
Judge, this is another information filed on Mr. Rosakis, Bryden Rosakis.
All right, this is cause number CR 25-241, State versus Bryden Paul Rosakis. All right, Mr. Rosakis, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. All right, give me just one moment, Mr. Rosakis, and I will find your paperwork. We'll go over real quick. All right, Mr. Rosakis, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you understand everything that you've read and signed?
Yes, sir.
You understand that you are asking the court to allow you to waive your right to indictment today, and that means that once you waive that right, the right to a grand jury indictment will not be restored to you, will not be given to you at a later date.
Yes, sir.
And has anyone threatened you, forced you, or pressured you to waive your right to an indictment in this case?
No, sir.
And you understand that you are, by waiving your right to indictment, you are allowing the state to prosecute you by the filing of what is known as an information. You understand that?
Yes, sir.
Do you have any questions about what it means to waive your right to indictment?
No, sir.
Okay. And while I'm here, let me go ahead and ask you, you are charged with what appears to be a third-degree felony offense of possession of a controlled substance in penalty group 2, greater than 1 gram, less than 4 grams. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison, and also a fine not to exceed $10,000 could be imposed. I see
Yes,
that
sir.
there is a plea agreement I see that there is a plea agreement in your case wherein you're asking the court to defer a finding of guilt. That means not convict you of the offense. You're asking the court to place you on 3 years community supervision. The court would be assessing a $1,000 fine plus court costs of $290, reimbursement fees of $515, and restitution of $180. And it appears to be a part of the agreement that the state would be asking the court to dismiss several cases that you have either filed against you or actually they're filed in the DA's office and they're not filed in court yet. Those being a possession of marijuana less than 2 ounces and another possession of a controlled substance in penalty group 2. Is that your understanding of the plea agreement, Mr. Rozakis?
Yes, sir.
All right. Mr. Manning, do you believe your client to be competent? And if so, is he entering into this agreement intentionally, knowingly, and voluntarily, including understanding the right to an indictment, and that he's waiving the same intentionally, knowingly, and voluntarily with the assistance of counsel?
Judge, he is competent. He is waiving both his rights to a jury trial, to confront and cross-examine witnesses, to testify, his right to a jury trial, his right to appeal, and he's also waiving his rights to an indictment in this case. I believe he's entering into those intentionally, knowingly, and voluntarily.
All right. Mr. Rozakis, any questions before we go any further about anything?
No, sir.
Okay. All right, then I would ask you at this time, how do you plead to possession of controlled substance of penalty group 2 greater than or equal to 1 gram less than 4 grams?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. The court will also find that the defendant has intentionally, knowingly, and voluntarily waived his right to an indictment in this case. Mr. Manning, any objection to the stipulation of evidence?
No objection is offered.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that this one's similar to the last case. The state does not yet have the DPS labs. I heard back from the labs today. They actually completed them. They just haven't finished the report, but we don't have those in our possession yet. But that's all that I would add.
All right, Mr. Manning, you and your client have discussed the issue of not having the substance chemically tested. Therefore, there's no evidence at this time that the state could offer as far as expert witness testimony that the controlled substance is actually a controlled substance.
That is correct, Judge. I've discussed that with him, as well as the fact that those documents would not be provided to us at this time, and my client waives both of those intentionally, knowingly, and voluntarily.
All right, thank you, Mr. Manning. All right, anything further from the defense?
Nothing further from the defense. We rest and close.
All right, court's going to review the evidence. Right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. Court finds that the defendant has waived the production of a Texas Department of Public Safety laboratory report regarding the controlled substance in this matter, has judicially admitted and confessed that the controlled substance is between 1 and 4 grams of THC. Based on the evidence, the court finds that there is enough evidence to convict the defendant. However, the court will follow the plea agreement and the court defers the finding of guilt on that charge. The court places the defendant on 3 years of community supervision, ordering him to pay a $1,000 fine, $290 in court costs, $515 in reimbursement fees, and $180 in restitution. Is that correct?
Yes, Your Honor. In this case, since the labs were completed.
All right. All right, the court, having assessed sentence, Mr. Rozakis, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Before I have you be fingerprinted, can you tell me how old you are?
19, sir.
19. Mr. Rozakis, have you ever been on felony probation before?
No, sir.
You understand that for the next 3 years, your life path can take some dramatic turns, either for the good or for the bad. Do you understand the significance and the importance of today?
Yes, sir.
Can you tell me why today is important?
Well, it's a turning point in my life. I have the opportunity to either make things better or make things a lot worse. And I choose to make things better.
Good. That's what I wanted to hear. I think the state has extended you an offer and an opportunity, and Mr. Manning has been instrumental in doing that. So I'm going to approve, and I've approved that today. So between the state, the defense, and the court, we're all giving you the opportunity to put this behind you and not let it mar the rest of your life. But we all want you to know that if you don't take and seize this opportunity, unfortunately, there's going to be consequences for that, and it could be consequences that stay for you the rest of your life.
Yes, sir. I'm very grateful.
All right. Well, I hope you have that attitude every day. Okay. All right.
Sir.
Thank you, Mr. Rozak. Step over to be fingerprinted. All right, Mr. Manning, if you want to go ahead and bring your next client while I'm signing.
Yes, Judge. September 14th to today is 46 days.
All right, Mr. Manning, who's next?
Judge, this is Mr. Posey. He originally was set for a writ today. However, the state indicted his case and we reached a agreement to resolve his case.
The criminal cause number on the docket or just the writ? Just the writ.
Okay.
Mr. Manning, do you have, well, I guess I've got it.
Should be on the paperwork.
Yeah, let me find it real quick. All right, before we proceed, Mr. Manning, so on the basis of the plea agreement, are you withdrawing the writ on behalf of your client and the court can dismiss that civil cause?
That is correct, Judge.
All right, court cause number CR 25-00053, State of Texas versus Randy Glenn Posey. Mr. Posey, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thanks, sir. You can lower your hand. Your name is Randy Glenn Posey, correct?
Yes, sir.
Mr. Posey, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning as your attorney and the work that he's done?
Yes, sir.
Do you have any questions about any of the plea paperwork that you signed?
No, sir.
Do you understand that the range of punishment for your offense is not less than 2 years in prison and not more than 10 years in prison and a possible fine not to exceed $10,000?
Yes, sir.
And you understand that a plea agreement in your case is upon you pleading guilty, the state's recommending that the court assess your punishment at 3 years confinement in prison, along with a $1,500 fine plus court costs of $290 and reimbursement fees of $85. You understand that?
Yes, sir. Yes, sir.
Mr. Manning, what kind of credit time is Mr. Posey entitled to?
Judge, after reviewing with the state submitted. We believe that his credit time is correct and agreed at 52 days.
So, Mr. Posey, you understand that you would receive 52 days credit towards that sentence for the time that you've already been in jail. You understand that?
Yes, sir.
All right, Mr. Manning, do you believe your client to be competent? And if so, that he's entering into this plea agreement intentionally, knowingly, and voluntarily after having been informed of his legal rights?
Judge, I do believe he's competent. We were able to review the discovery, and he was able to assist in any issues that we have with the case. I believe he is entering into this plea intentionally, knowingly, and voluntarily.
Very well. All right, Mr. Posey, I would ask you at this time how you plead to the third-degree felony offense of assault of a family or household member with previous conviction.
Guilty.
Are you pleading guilty to this crime because you are guilty of committing that crime?
Yes, sir.
Does anyone threaten, force, or pressure you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt. Mr. Manning, any objection to the evidence?
No objection as offered.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Your Honor, only that the state is in compliance with victim services. There was a VIS filed in this case, which has been provided to the court. Additionally, Your Honor, the victim indicated that she did not wish to take an active role in this case.
Thank you, Mr. Hartwell. Anything further, Mr. Manning, from the defense?
Nothing from defense, Judge.
All right, court is going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. The court follows the plea agreement today. The court hereby convicts Randy Glenn Posey of the third-degree felony offense of assault of a family or household member, previous conviction. Court assesses punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,500 fine. Court costs of $290, reimbursement fees of $85, and the court awards Mr. Posey 52 days credit towards the sentence for the time that he has spent in jail on this cause. Mr. Posey, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from prison, if you've not paid off your fines and fees, you're ordered to report to the courthouse to make a payment arrangement. Otherwise, the court could issue a warrant for your arrest, okay?
Yes, sir.
All right, please step over to be fingerprinted. Want to get your next client?
Sorry, Judge.
You want to get your next client?
Yes, Judge. Gregson.
Is this Amber Gregson?
Yes, Judge.
This is cause number CR 23-182, State of Texas versus Amber Elizabeth Gregson on the state's motion to revoke. Go ahead, Mr. Manning.
Judge, I was just appointed on Ms. Gregson's case. I was provided a copy of the motion. I anticipate being able to go over that with her and have a either a potential resolution or a way forward in our next setting.
All right, court will set we'll set Ms. Gregson for the next evidentiary docket on December 16th. If you come up with something sooner than that, Mr. Manning, just notify Ms. Tabraham like you always do, and we could
Yes, Judge.
get you in a couple weeks earlier on the 4th.
Thank you, Judge. I'm sorry, I missed the date. What was the date for the next contested hearing?
16th
Of
December. I'm sorry. Yes, sir. Mr. Manning, next.
Judge, next ready on Mr. Deal.
Nicholas Ryan Deal.
I'm sorry,
20.
Judge, I apologize. He just stepped out to go to the restroom.
No problem.
We can move to Ms. Gonzalez.
Danielle Nicole Gonzalez, CR 25, 231, 232, and 233. Ms. Gonzalez is set for arraignment. Do you need those
Judge,
indictments?
yes, Judge, if you don't mind, I was unable to pull those up to review them with her here at the jail.
Yeah, give me just one moment.
Thank you, Judge. So he's involved in the indictments. I can see the training spelled correctly. You understand each of the charges you've been charged with. Okay. Judge, let's just all turn.
All right, Mr. Manning, they're on the screen. They may be a little bit out of order, but when you're done, just let me know and I'll move to the next one.
So the first one is assault of servants. The third degree felony is an ignorance. Second degree felony, which is range behind for 10 years up to 20 years. That's an intentionally no unviolated. Not guilty to that. An against it is actually used to Judge, at this time, my client understands the charge
Wait,
against
hang on,
her as well as.
Hang on just a second. Let me show you the other two also.
Okay.
They just popped up.
Is your name spelled correctly?
Yes.
Yes. This one is a first degree. Second. First. Second, was probably said that you stepped on the map. That one as well. And we're ready for the final one.
If I need to make it larger, just let me know.
Surveillance officer as well. That one. My client understands the range of punishment in each of the charges as well as the charges that are against her. Her plea is not guilty. Her name is spelled correctly and she requests to be set on the pretrial docket.
All right, the court finds she's waived the formal requirements of arraignment, enters her plea of not guilty into the record, and the court sets Ms. Gonzalez for pretrial hearing. Do you want that December 4th date, Mr. Manning?
Yes, Judge.
All right, court sets Ms. Gonzalez then for pretrial December 4th in each case.
Thank you, Judge. Let's go.
All right, who would you like next?
Judge, if we'd like to go back to Mr. Deal.
Nicholas Ryan Deal, cause number CR 25, 227, 228, and 229. Will you need indictments, Mr. Manning?
Yes, Judge.
All right, stand by.
right. Say it. That's what he said. That's certain evidence here.
All right, there you go, Mr. Mayor.
You judge. So. Just see. I agree. So if things not correctly. Judge, my client's name is spelled correctly. Oh, I apologize.
There's two more.
Says you see your driver's license. So, okay, so let me go to that. You're ready for the last one. Yes. For another child. This is full driving. It's officer out. That as well. Mr. Deal's name is spelled correctly. He understands that each of the charges, as well as the range of punishment for each, he pleads not guilty and requests to be set on the pretrial docket.
All right, the court sets Mr. Deal then for pretrial on December 4th in each case. Finds that he's waived the formal requirements of arraignment, and the court does enter his plea of not guilty into the record. Who's next, Mr. Manning?
Judge ready on Mr. Clint Mills.
Mr. Mills, come on up. You need the indictment.
Yes, Judge.
There you go, Mr. Manning.
Felon offender that's going to hide your life. That is your name. Wade Mills says spelled correctly.
Judge, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment. This time he pleads not guilty and requests to be set on the pretrial docket.
All right, the court enters Mr. Mills' plea of not guilty into the record, finds he's waived the formal requirements of arraignment, and sets Mr. Mills for a pretrial hearing December 4th at 1:30. Mr. Manning, who's next?
Judge, next ready on Mr. Earl Mosley.
Earl Eugene Mosley, CR 25-236.
And Judge, we'll also need the indictment on this one.
There you have it.
Thank you, Judge. So, charge you with a second degree felony. Second felony. And you turn the property up. Like, no, you don't put that on and keep requesting that discovery. Judge, my client's name is spelled correctly. He understands the charges against him as well as the range of punishment. We ask this case to be set in the pretrial docket so we can get discovery.
All right, the court enters his plea of not guilty into the record, finds he's waived the formal requirements of arraignment, sets his case for pretrial December 4th at 1:30.
Sign right there. We'll see what you done. Yeah.
Mr. Manning, who's next?
Judge, if I may just have a moment to speak to Mr. Crowder. I don't know if Mr. Schmidt's ready to handle some of his business. That's great. There's always have a moment. Well, man.
All right, Mr. Schmidt, give me just one moment. Let me pull up everything. All right, Mr. Schmidt, is Miss Daly pleading in both cause numbers?
That's correct, Judge. We have a motion to revoke and a new offense.
All right, Ms. Daly, this is cause number CR 14-460, CR 25-198, State of Texas versus Michelle Lynn Daly. Ms. Daly, I'm going to ask that you raise your right hand so I can place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, you can lower your hand. All right, Ms. Daly, you have two cases before the court. The first one's CR 14-460. In that case, you appeared before the court previously back in August 25th of 2015. And on that date, you pled guilty to evading arrest or detention with a vehicle, a third-degree felony. And it appears that the court entertained a plea agreement. The court assessed your punishment at 10 years confinement in prison and suspended that sentence that same day and placed you on community supervision for a period of 10 years. And the court also assessed a $2,000 fine. It was during your period of community supervision that the state filed its motion to revoke your community supervision, and they have alleged two separate allegations of violations. And have you had enough time to review those allegations with your attorney, Mr. Richard Schmidt?
Yes, sir.
Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes,
Do you understand everything that you've read and signed today in your plea agreements regarding both this case and also your new charge of tampering with or creating fabricating physical evidence?
yes, Your Honor.
Do you have any questions about anything before we go further?
No, sir.
Okay, let's talk about your other case in CR 25198. You are charged with the third-degree
Okay.
felony offense of tampering or fabricating with physical evidence. That does carry a range of punishment of not less than 2 years in prison, not more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in that case is upon you pleading guilty, the state's recommending that the court find you guilty, assess your punishment at 5 years confinement in prison, along with a $1,000 fine and court costs of $290 and reimbursement fees of $20. And your sentence in that case would run concurrent with the sentence that's being recommended in your probation case. And that sentence recommendation is upon you pleading true to those allegations of violations of your community supervision, that your community supervision be revoked and you be assessed 5 years confinement in prison on that case as well. In addition, you would have to pay the balance of your financial obligations. Mr. Schmidt, what kind of credit time does Ms. Daly have to her sentences?
On the CR 14 case, she has 167 days credit time. And then on the CR 25198, she has 107 days credit time.
So, Ms. Daly, you would get credit towards your sentence for those days that you have spent in jail on each cause. You understand that?
Yes, sir.
So, Mr. Schmidt, do you believe Ms. Daly to be competent today to enter into these plea agreements? If so, she's doing so intentionally, knowingly, and voluntarily, in your opinion, after you've explained to her her legal rights?
Yes.
All right, Ms. Daly, let me ask Mr. Schmidt, is Ms. Daly waiving the formal reading of the state's motion to revoke?
Yes, sir, we are.
And is she pleading true to all counts?
Yes, sir.
All right, Ms. Daly, with regards to count 1 and 2 in the state's motion to revoke, are those counts true or not true?
True.
And then let me ask you in regards to CR 25198, tampering or fabricating physical evidence, how do you plead to that offense?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Ms. Daly, has anyone threatened, forced, or pressured you to plead true or plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged, and the court will accept the defendant's plea of guilt to the offense alleged. Mr. Schmidt, any objection to the evidence offered in either case?
No objection.
All right, the evidence is admitted in both cases, and the court does take judicial notice of the defendant's judicial confession in each case. Mr. Hartwell, anything further from the state?
Nothing further, Your Honor. Thank you.
Mr. Schmidt, anything further on behalf of Ms. Daly?
No, sir.
All right, then, based on the evidence presented to the court finds that Michelle Lynn Daly has violated the terms and conditions of her community supervision. Court finds both count 1 and count 2 to be true. Court will follow the plea agreement today. The court hereby revokes her community supervision, assesses her punishment at 5 years confinement in prison, orders her to pay the balance of her financial obligations, and awards her 167 days credit towards her sentence in that cause. And in the new cause CR 25198, court hereby follows the plea agreement. Court convicts Michelle Lynn Bailey of tampering or fabricating physical evidence, a third-degree felony, assesses her punishment at 5 years confinement in prison, orders her to pay a $1,000 fine, $290 court costs, and $20 in reimbursement fees, and the court awards her credit in that cost of 107 days for the time that she's already spent in jail on this cause. All right, Michelle, when you get out of prison, if you've not paid off your fines and fees, you need to report to the courthouse, to the district clerk, and talk to them about a payment arrangement so that you can avoid being arrested on CAFIUS pro fines. Do you understand?
Yes, sir.
Michelle, you and I have known each other for a long time, haven't we?
Yes, sir.
A long time. Beginning when I was DA, and then
Yes,
most
sir.
recently as I've been judge. This has been a long time, and I don't want to pile it on because you are accepting responsibility for your actions today. But I do want to say I'm seriously disappointed in you for trying to fake your own death.
Yes, sir. I know.
You're better than
I
that.
was not in my right mind.
Well, I believe that, and I know that, Mr. Gann and I talked about it at length. And had you done the right thing, I think you probably could have avoided a lot of your circumstances that your consequences really that you're suffering here today. So go do your time and come out and don't make such dumb decisions because you're better than that. Okay.
Yes, sir. Thank you.
You're welcome. Ms. Daly, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Mr. Schmidt, give me just one moment. I'm going to sign this paperwork and I'll be right with you.
He's got 30 years now.
As a whole.
I think that has whole division, but what do you think?
Never thinking so.
I don't know, who's not in the picture. Easy, not true. Yeah, few years after it.
Ms. Taberham,
Yes, Your Honor.
I hope I didn't make a mistake, but I might have. I think I might have. No, I don't think I did. Okay. I thought I might have switched up the credit time on Miss Daly, but now that I look at it, I think I'm correct. But you might want to just double check when you see it come in on your end that it's
Okay.
107 days on the newer case and 100. I'm correcting the 167 days on the older case, but I want to make sure that I didn't transpose those. It'll just be an extra set of eyes. I appreciate it.
Okay, I will.
All right, Mr. Manning, who are you ready on?
Judge, this is Mr. Crowder. As we were preparing for our writ hearing, we have an announcement to make.
All right, go ahead. And this is WR 25-38, Kavondre Crowder versus State of Texas. Go ahead.
Yes, Judge, as we were making final preparations on a writ hearing, Mr. Crowder and I were discussing some things, and I received an offer, pre-indictment offer from the state to resolve his case, his DWI case, and reject the other two cases. My client has agreed to accept that offer, so we withdraw our writ and request to be set for a pre-indictment plea.
Okay, you want December 4th?
Yes, Judge.
All right, court will finds that the petitioner has withdrawn writ number WR 25-3A. The court orders that dismissed. And I'll go ahead and set you on the docket, and then I guess you'll have to file the CR number by information. So court will set Mr. Crowder for the 12-4. As soon as it's filed, I'll need a cause number to do that.
Yes, Judge.
Manny, do you have
Judge,
any
I'll do
other
that.
clients in the jail?
No, sir.
Abraham, is there anyone else at the jail that we need to see?
No, Your Honor.
All right, very well. I appreciate everyone's work this afternoon. Thank you to the state. Thank you, Mr. Schmidt. Thank you, Mr. Manning. Thank you, Ms. Burns. Thank
She's already
you.
left.
It's like my third one. Oh, she has? Karen Burns
Yes, sir.
of the probation department, the dean director of community supervision. I was gonna personally thank her today for all of her hard work and give her a shout out here on YouTube, but I guess I won't do that now. And so thank you to Deputy Martinez and to Patty Abraham, Stella Grisham, and to anyone else that I've missed. Thank you for your work today.
Thank you, Your Honor.
You'll give us about 5 minutes. I need 2 signatures before you.
Yes, ma'am. I'll be here waiting on you.